Good afternoon, everyone. Welcome to Economic Matters. We're here this afternoon for our voting list number 20. We have 4 bills on the docket. It got revised as there's a couple of pieces of legislation that still need to be worked on. With that said, we're going to begin with Senate Bill 94.
Times before. We passed it out last year, where this is about the Earned Wage Access Bill. This is about products that look at your pending salary and provide you a loan against that. And we passed out a version last year. I think it came back this year to make sure we remove tips from that. It's a departmental bill, as well as put in some stronger consumer protections. I don't believe the House bill has, are they conformed? You're not used to be the sponsor of this bill. I'm not sure if you're.
I didn't sponsor it this year.
You didn't sponsor it this year. So I don't know if the plan is to conform the bills to be the same. The one comment I did want to make is that the understanding is that this bill, with this version, goes into practice in October, and the expectation that any companies that were operating based off of last year's term will have time until October to correct any sort of issues they've had with providing tips. Otherwise, we should go forward. Favorable.
Favorable. Senate Bill 94 has been properly motioned as favorable and second. Any discussion? Delegate Adams.
Thank you, Chair. I don't know if it's possible to hold the bill. There are a couple of amendments I'm aware of, at least one that relates to a safe harbor. I think the tips conversation appears to be reconciled, but I'd like to hold the bill for the purpose of amendments.
My thought was that the understanding that would the safe harbor be needed if we know the bill doesn't go into place until October?
So the amendment that I'm imagining is independent of the effective date, but that's.
If I may, Delegate Adams, I would like to have, is someone from OFR here to come before? Thank you very much.
Good afternoon, everyone. My name is Amy Hennon. I am the Assistant Commissioner for Policy at the Office of Financial Regulation. So with regard to the safe harbor question, our office believes that this is not necessary because we have licensed a majority of the providers at this point, and the safe harbor doesn't serve the purpose of it only. The need for the license already exists, and so this would only serve as the purpose of providing a safe harbor for things like the non-discrimination clause that's been added to this year's language.
So the purpose of the special order is not to stop the bill's passage, it's to give me time to advance the concept of it. And I don't currently have the amendment in hand, else I would be debating the amendment, or at least discussing it. So it's a polite hold till the next voting session, if we could.
Yeah, I would urge us to continue with the vote today. I think we've looked pretty significantly into this question about the safe harbor and determined that it's not necessary. And I think there's the removal of the tip component is the crux of what the bill is. So I think an amendment to remove that would sort of remove what the vast majority of what the bill does. So I would urge us to move forward with the vote today and continue with the favorable proposal.
I do have a question, though. Do we have pending, do we know that there's pending legislation against any company? Because I don't think that's the intent of the legislature regarding this bill.
You mean pending
litigation?
I'm not aware of any pending litigation. My office is not taking any litigatory action.
Would the Office of Attorney General be taking any?
I'm not aware of any action by the Attorney General's office.
Delegate Adams, if I could suggest you could do an amendment on the floor, second amendment or third.
Oh, I think I've done plenty of those this year.
It's okay. I would suggest
I
that.
do think that's an important issue to get resolved.
I mean, I think there are companies out there that are not currently licensed, and I think you're trying to hear at least some concern for, while we're in place trying to pass a bill, that we're allowing for the unlicensed companies to, in effect, come into compliance with what we're doing. And while the effective date might be a path forward, I'm of the opinion that the safe harbor is not hurting the legislative intent. And I'm also not trying to kill the bill by passing this vote off to a separate date. I'm simply saying that another day at least gives us a chance to look at legislative language. But that's as far as I'm going to take it.
Is the bill prospective?
I think it's the other way, because I think the bill has a look back once it becomes, I mean, that's the problem.
So let's
Delegate Pippy?
sure. Let's get the committee council working. So is, oh, okay, yeah, he shook his head no. I was like, oh, okay. He's like, nice try. So let's just iron this issue out. The bill is not prospective, correct?
It's not prospective?
Prospective, sorry. Prospective.
So it's not retroactive.
Wait, so,
It's only prospectively, yes.
I understand. So, but the concern is what would happen between now and when the bill kicks in? Is that right we're talking about? October 1st?
So I believe that
Yeah, go ahead.
Sure. I believe the concern is that you've got companies that are in the process of getting licensed, and that the bill potentially could be viewed as being retroactive. They could look back. And so that's the crux of the problem. So whether or not the Attorney General says they will or won't, I think the legislative intent is to pass the bill, have it be effective a certain date. The safe harbor would have some degree of helping these businesses as they're moving forward to not feel like they're going to be facing a complaint from the Attorney General's office. So that's the purpose of the safe harbor.
If we let it roll, I mean, not that we could per se stop it, but if no one tries to do anything and then he proposes an amendment just to clear up that issue, would that be considered a friendly amendment on the floor?
Madam Chair, I guess it sounds like you want more time to look into it. My analysis of it is that that's not necessary. Having had significant conversation with the Office of Financial Regulation, the Attorney General and others. So I don't think that the intent is to do gotcha on anyone. And we can disagree about what policies are right, but I don't think anyone's supposed to be gotcha'd on this, and that I wouldn't support it if people were being gotcha'd. But so I think that the reason that I don't think it would probably be a friendly amendment is because our analysis is that it's not necessary. You had asked for more time to look at it to see if you thought it was needed. And so if you look at it and you determine that it is needed, we can have another conversation about how you reach that conclusion, and possibly it would be a friendly amendment. I think at this time, our analysis is that it's not needed, so it wouldn't be considered friendly. But if you need more time to kind of reach that conclusion yourself, that remains an open possibility for you.
Are we voting tomorrow? We voting tomorrow?
Yes.
Okay. So can he hold it till tomorrow so we can meet with those people and then we'll give you an update?
Okay, we will hold it till tomorrow.
Perfect, thank you.
Senate Bill 94 is held till tomorrow's voting session. We'll move on to Senate Bill 335.
Thank you, Madam Chair. Senate Bill 335, you all might remember this bill. This was a bill that Senator Love brought, but also I think this is the bill that we more famously known by Delegate Von Stewart's testimony on the bill. There are several amendments to the bill. What the bill does, it prohibits a landlord from rejecting a prospective tenant who uses an income-based housing subsidy on the basis of specified financial information, and requires the landlord to offer to report a tenant's positive rental payment. The amendment that we have here, strike the word utilities to limit income verification to the portion of rent not covered by the housing subsidy, and as the failure to pay utilities as a commercial, reasonable, and non-discriminatory ground for a landlord to refuse to rent to a tenant with a housing subsidy. I ask you to move the amendments.
Move the amendments. And then there's another amendment I need to add. Okay, and then, Madam Chair. There's one other issue. We've been working really hard to line this up with what's coming out of the Senate, and this is just a technical piece. The Senate added a section at the end of the bill that's related to positive rental history, but there's a section in our bill that says this section applies only to a landlord that owns 6 or more residential units. It's on the last page of the bill, or second to last page of the bill. That's not in the Senate. So I would, by voice amendment, ask that we strike that language so that what we are moving matches what the Senate is moving. That's my amendment. I'm moving favorable.
Second.
Okay. So
All
then-
those, any discussion or opposition to the amendments being offered? Seeing none.
Move favorable as amended.
Senate Bill 335's been motion properly favorable as amended and second. Any discussion?
Oh, I'm sorry. Hang on one second. I apologize. I'm adding, not removing that section. That's in the Senate bill, not in the House bill, that it applies only to that it owns, to landlords that own 6 or more residential units. My mistake.
Is there any discussion on the revised amendment? Seeing none.
Okay. Move
there-
favorable as amended.
Again, Senate Bill 335's motion properly favorable as amended and second. Seeing no discussion. Vice Chair.
Yes.
Delegate Turner. Yes. Delegate Fennell. Yes. Delegate Pruski. Aye. Delegate Howard. No. Delegate Johnson. Aye. Delegate Wafo's excused. Delegate Bandari.
Yes.
Delegate Rogers.
Yes.
Delegate Chi.
Yes.
Delegate Aaron's.
No.
Delegate Queen.
Yes.
Delegate Amprey.
Yes.
Delegate Adams. Delegate Pippy. Delegate Crosby is excused. Delegate Rose. Delegate Wyval. Delegate Roberts is excused. Chair votes aye. Senate Bill 335 passes 11. Senate Bill 387.
Senate Bill 387 is the dynamic price setting bill. The Senate made significant changes to it, mostly related to exceptions, and they changed the price setting to price increase that's prohibited. And those are the primary changes that are made. We'll move the bill favorable.
Senate Bill 387's been properly motioned favorable and second. Delegate Adams and then Delegate Rose.
So we are taking the Senate's bill version of this? Okay.
I think that was my question. The retailers had a concern, but they like the Senate, so, okay. Okay, thank you.
Delegate Queen.
For clarity, so where we have a cross-file, we're going to conform the House version to that Senate bill in this case?
The House version is in the Senate, and they just amended the House version to match what they did, so we have possession of the Senate's bill. The two are going to match.
Seeing no further discussion. Delegate Aaron's.
Yeah, did they erase any of the unfavorables with the amendments?
It's our understanding that the retailers got all of the amendments that they requested over there. I'm not sure about the other, there were several others. I know they made several changes for the various industry groups. I don't know exactly where everyone stands on it, though.
Delegate Rose.
Okay. So you're not sure about the unfavorables? The retailers are here. Is everybody in favor?
We had technical changes
Okay. Okay.
And if I may, is Miles here? Okay. If you wanted to just share some information.
Yes, good afternoon. And yesterday, the Senate did, or specifically Senate Finance did vote this bill out. They did make a number of changes to the definition of third-party provider. Those came from, I think there's a number of lobbyists for those firms in the room as well, if they wanted to comment on those. But we took some amendments from them as well. A number have been taken from the retailers. You also see that they've changed the increase that was in the Senate bill to set a higher price. In general, we have worked with a number of different lobbyists, advocates on this bill to try to find a middle ground.
Okay, so based on what you just said and what Ms. Locklear just said, and my understanding of this bill in its present situation, I'm going to hold this bill just to make sure we see those amendments that was mentioned before we move forward.
Okay, good.
Okay, yes, I also got them on my way over here, so.
I'm sorry?
I also just received the amendments
Okay.
as I was coming over
So
here.
387 is on hold till next voting session. Thank you, Miles. Thank you, Ms. Locklear.
Thank you.
Next bill is Senate Bill 763.
Bill 763 establishes the Maryland Growth Initiative within TEDCO to support the growth of startup companies in Maryland. The governor must appropriate $5 million annual budget for the program, and the program would specifically focus on supporting those companies at the phase of between early startup and the scaling, which is oftentimes when they run into a challenge called the Valley of Death. It would provide technical and financial support for those companies. It moved unanimously out of the committee as well as the entire Senate.
I'll move favorable.
Senate Bill 763 has been properly motioned favorable and second. Is there any discussion? Seeing none. Vice Chair?
Yes.
Delegate Turner? Yes. Delegate Fennell? Yes. Delegate Pruski? Aye. Delegate Howard? Yes. Delegate Johnson? Aye. Delegate Boafos excused. Delegate Bandari? Yes. Delegate Rogers? Yes. Delegate Chi? Yes. Delegate Aaron's? Aye. Delegate Queen? Yes. Delegate Ampry? Yes. Delegate Adams? Yes. Delegate Pippy? Yes. Delegate Crosby is excused. Delegate Rose? Yes. Delegate Weigel? Yes. Delegate Roberts is excused. Senate Bill 763 passed majority 16. All right. Members, that is the last bill on our docket for this afternoon, and given the bills that we've held and that are forthcoming, we will have another voting session tomorrow. I don't have the time just yet, so stay tuned. Thank you. We are adjourned. We're back on the floor at 4 p.m.